SwayamPrabha. Digital India. Educated India.
Hello everyone, welcome to the second lecture on our course on law of copyright, patent, trademark and other IP. In the first introductory lecture, I discussed about the meaning of IP, the kinds of IP, and we discussed about three basic forms of intellectual property: copyright, patent and trademark. We also discussed the international developments in relation to these three. I am sure you by now you are aware that the subject matter of copyright is works, subject matter of patent law is invention, and subject matter of Trademarks Act is mark which a trader uses in the course of his trade. I said we'll start with copyright, we'll devote some 5-6 lectures on copyright, maybe then we'll talk about patents, we'll devote 4-5 lectures on trademark, and finally towards the end I'll be talking about other forms of IPR like GI, like designs, industrial designs and protection of plant varieties and Farmers' Rights Act. So let's start with our discussion on copyright law. We'll be discussing it in a bit detail as compared to what I mentioned in the first class. And as I said, the first task of any IP legislation is to identify the subject matter which it regulates. And therefore, this lecture is devoted on the subject matter of copyright. Let me first of all clarify that under Copyright Act, as I said, we are concerned with works. But let us first of all understand that idea is not the subject matter of copyright. It is the expression which gets copyright protection. So if I think about some story, unless I write that story on a piece of paper or I type it, I will not claim patent copyright protection on that work. So there is something called as idea expression dichotomy, which will come maybe a bit later. So let's first of all understand that idea is not the subject matter of copyright, howsoever brilliant it may be. The second important point is, by and large, in relation to most of the subject matter, we will not get into determination of quality. So quality determination will usually be not done except for one or two subject matter. We will discuss that later on. So there are 2 points. Idea is not the protected subject matter. It is the expression of a work which will get protection. Second, in Copyright Act, except for one or two subject matter, we will not determine the quality of the work. We are not concerned with the quality of the work. What I am trying to say, you do not have to create something really high in terms of quality to claim copyright protection. Okay. Now let us see what the law says about the subject matter. Starting with the American law. The American law says that any original work of authorship which is fixed in any medium is the subject matter of American copyright law. So what all it says a work of authorship is the subject matter. The condition is it must be original, and another condition is it must be fixed. So therefore, there is an open-ended provision. Protection will be granted to any work which is original, which is fixed. And then what it does, the provision gives an illustrative list. Literary work is protected, artistic work is protected. So the list is not an exhaustive list, it is only an illustrative list. Such a provision of subject matter is an open-ended provision. In addition to that illustrative list, the provision also identifies the exceptions. It says that idea is not the subject matter, concept is not the subject matter of copyright, principles, etc. These are not the subject matter of copyright. So there are 3 things: it tells me the subject matter, it tells me the criteria, it gives me the exceptions. Such a list of subject matter is an open-ended provision. It does not give me an exhaustive list. So, we have liberty to claim protection on things which are not enumerated there. Whereas under Indian law, you see there are two differences. One, the list of subject matter which will get protection under Copyright Act is a closed list. We have an exhaustive list. Only these works will get protection. Literary work, dramatic work, musical work, artistic work, sound recording, cinematograph film. So, only these subject matter will get protection. So, the list is a closed list. It is an exhaustive list. So, on that point my law is different. The second point is, as I mentioned, in American law they have clearly identified the exceptions, what is not protected. Whereas in case of Indian law, the exceptions have been laid down by courts in different cases. So, the list of exceptions which we have as to what is not protected is something which is judicially crafted. So, on these 2 points, Indian law is different from American law. Now, if you go back to the American provision, originality is mentioned as a requirement. In Indian section 13, we will see originality is a requirement mentioned. In American provision, the work in question must be fixed. In our law, we do not have a written requirement of fixation, but let me tell you, fixation is a precondition for getting protection under Indian Copyright Act 1957. Although it is not written, it is still a precondition to get copyright protection under Indian law. What do we mean by fixation? Fixation of a work means converting an intangible work into some tangible form. So, that is how you fix it. So, I may say something, it is not fixed. Whatever I am saying is literary, but it is not fixed. If it is recorded, if it is written, if it is printed, it is fixed. Fixation, therefore, as I said, is a precondition to get copyright protection. It is written in American law. It may not be written in as many words in Indian law, but still a requirement. Now, coming to section 13 of Indian Copyright Act, it gives me the list of things which are protected under Copyright Act. It says copyright shall subsist in what? It shall subsist in literary, dramatic, musical, artistic works, but not all of these are protected. Only those literary, dramatic, musical and artistic works are protected which are original. We will understand the meaning of originality later on. Then in clause B, it says cinema is a protected subject matter, cinematograph film is a protected subject matter. And you see there is no word original written here. So, that means apparently it shows that cinema need not be original. There is no requirement of originality in cinema, and same is the case with sound recording, phonogram. There is no requirement of originality in a sound recording. In order to, therefore, under Indian law, in order to get protection, there are 2 requirements. One, the work in question must fall in one of the identified categories. It must be either literary, dramatic, musical, artistic, either cinema or sound recording. So, it must be one of these, and it must be original, at least for first 4 works which are there in 13(1)(a), these have to be original. So, these are the requirements. Now, there is an interesting point which I would like to highlight. In the previous lecture, I said Rome Convention of 1961 came for the protection of neighboring rights. And there are 3 beneficiaries of neighboring rights: performer, phonogram producer and broadcaster. So, internationally we understand that sound recording is not the subject matter of copyright. Internationally, in Rome Convention, even in TRIPS agreement, we understand that sound recording is a subject matter of neighboring rights. But what I wanted to highlight here is, in Indian law, sound recording is protected under copyright. So, therefore, we do not grant neighboring rights to the producers of sound recording, we grant copyright protection. This is an important point to observe. In relation to cinema, I may tell you that in UK, it is a hybrid category where protection is granted to producer as well as director of cinema, whereas in Indian context, producer is the sole author, considered as sole author of the cinema. So, that is how my provision is slightly different from some international developments and some of the foreign laws. Sound recording particularly is relevant because in many countries, particularly in civil law countries, producers of sound recording get protection under neighboring rights category. Now, I said there are two requirements. One, the work in question must fall in one of the identified categories, and second, literary, artistic, dramatic and musical works must be original. What do we mean by originality of a work? In the case of Macmillan and Company versus K and J Cooper, the English court said that in order to be original, the work in question must have some quality different from raw material. So, most of the works are derivative in nature. You read n number of articles to finally prepare your article. You read many poems, get inspired, and then you write your poem. So, therefore, most of the articles are inspired, are derivative. Now, what this case says, in order for your work to be called as original, your work must have something qualitatively different from the raw material on which you have based your work. So, there is a comparative test suggested in this case, which I think is not a wise idea, because comparative test can be used in patent law to determine novelty. Whether my invention is new or not, compare it with rest of the world and see if there is something similar to it. If there is nothing similar to it, it is new. So, a comparative test can be adopted to determine novelty. Originality is not something which can be determined by adopting comparative test. There are many such words. For example, whether the action of government is reasonable or not cannot be determined by adopting a comparative test. It is an inherent thing which has to be determined. Fairness, for example, reasonableness, for example. Same is the case with originality. And a test different from what the court in Macmillan says came in the case of University of London Press versus University Tutorial Press. This is 1916 Chancery decision. Justice Peterson writes a paragraph to explain the meaning of originality, where he says that originality in copyright law does not mean originality of idea. As I have already said, idea is not the subject matter of copyright. Originality relates to originality of expression of that idea. He further says that originality does not mean novelty of the expression. Your expression need not be new. It can be derived. It can be based on some existing expressions. What is important here is that your expression must originate from you. What is important here is your invention must not be the result of copying. So, therefore, what I understand is, if you have not copied, if the work originates from you, the work in question is original. But the next question is, when can you say that the work has originated from you? You can say that the work is originated when it is the result of application of your labor, your skill, your judgment. So, what we can conclude from the decision of Justice Peterson is that a work is original if it is the result of application of labor, skill and judgment of the author. If the author creates the work by employing his labor, his skill, his judgments, then whatever he creates is an original work. We can say that it has originated from the author. This test is called as sweat of brow test. So, how to determine originality? See whether it is a result of application of your labor, your skill, your judgment or not. If the answer is yes, the work is original. But then there are two questions associated with it. There are two questions associated with sweat of brow test. We said apply labor, the resulting work will be original. There are two questions. One, how much of labor will create originality? Two, what kind of labor will create originality? Now, if you recall in the first slide itself, I said that the first thing is to understand that by and large we are not going to talk about quality in copyright. We are not going to create something really high in terms of quality. Now, how much of labor will be required to create something which may not be very high in terms of quality? Very small amount of labor will be good enough. That is the law, therefore. So, what amount of labor is required to create originality? A very small amount is good enough to create originality. So, the threshold of labor required to create originality in the work is very low. Then the second question, what kind of labor? You see, I have identified 4 kinds of labor which cannot create originality. Rest of the labors will create originality. First, when you are applying labor and there is no change in the resulting work, you end up creating something which is identical to some other work. such a labor will not create originality. Second, you are applying labor, there is some change in the resulting work, but the change is not because of your labor, the change is because of some mechanical process. Then your labor will not be sufficient to create originality. Third, when you are applying labor, there is some change, the change is because of your labor, but the change is very insignificant. Change is very insignificant means that it is so trivial that nobody will notice it. For example, there is a novel which contains many legal terms, an engineering student will not be understand that novel. What I will do, I will take that novel, replace those difficult words, maybe some 100 words out of a novel of 1000 pages. I have replaced 100 words with easy to understand words, and I am claiming copyright on the new product which I have created. That will not be granted because the change, yes, it is because of my labor, but the change is very insignificant. And the fourth kind of labor is wrong kind of labor. You are writing a literary work, I am drawing something around it, I am applying artistic labor, I cannot be a joint author of the literary work, right? So these are the four kinds of labor which cannot create originality. You apply labor, there is no change in the resulting work. You apply labor, there is some change, but the change is because of mechanical process. You apply labor, there is some change, the change is because of your labor, but the change is insignificant. And fourth, when you are applying wrong kind of labor. This is the test called as sweat of brow. So whether a work is original or not will be determined on the basis of application of labor, skill and judgment of the author. If the work in question is the result of application of your labor, how much of labor? Very small is good enough. Why very small is good enough? Because copyright law is not concerned with only those works which are high in terms of quality. Very low in terms of quality, still protection will be granted. So therefore, to create that, you don't need to apply a lot of labor. What kind of labor I mentioned? There are four kinds which cannot create originality. That brings us to the second test. The second test to determine originality is called minimum modicum of creativity test. There was a case called as Feast Publications Incorporated versus Rural Telephone Service Incorporated. This was an American decision. Feast Publications versus Rural Telephone Service Company. This was a case in relation to a compilation. I have to prepare a telephone directory, for example. What I will do, one way is to collect the information first hand, visiting all the homes, all the houses, collect the information, prepare a directory. The second thing is, there are existing directories of various service providers, copy from their directories and prepare a new compilation. When a new compilation was made, the other service providers filed a case of infringement. Now what I am saying, I have copied from something which was not original. Your database which you prepared on the basis of information of your subscribers, that database, that compilation itself was not original. So if it was not original, whatever I have copied from it will not amount to violation of copyright. Now court says that we are rejecting sweat of brow test. We understand that anything which is created merely by applying labor will not become originality. There must be some minimum modicum of creativity in that work. So routine databases compilations cannot be considered as original, and copying from those databases would not amount to violation of copyright. In order to claim copyright in compilation, court says the resulting work must emerge, must come into existence because of application of your labor, plus there must be some minimum modicum of creativity in that work. Now this judgment is further explained in another case called as CCH Canadian Limited versus Law Society of Upper Canada, in which court explains the amount of creativity required in the work. This is another case on creativity test, and it says that to claim copyright in a compilation, the author must produce a material with exercise of his skill and judgment. So you need to apply labor, and there must be creativity. You need to apply labor, skill and judgment, there must be creativity. Now, how much of creativity is required is explained here, not in the sense of novelty, not that we want to create something which becomes absolutely new, but yes, there must be some creativity. Not in the sense of non-obviousness. Non-obviousness means we don't want to create something which becomes non-obvious to a person skilled in that art. We are not going to create a painting which is absolutely non-obvious to a painter. So, we don't require high degree of creativity. We don't want to create something which is entirely new. We are not going to create something which is entirely non-obvious to a person skilled in that art. So, therefore, this explains the amount of creativity required. The threshold of creativity again is very low, but then there must be some creativity. So, what these cases have done, these cases have discarded the sweat of brow test. But what is important to observe here is both the cases, whether it is feast versus rural or whether CCH Canadian Limited, both these cases relate to compilations. So, whatever judgments we have in relation to creativity test as the appropriate test to determine originality, these are there with respect to compilations. Now, coming to Indian law, we have a case called as Eastern Book Company and others versus D.B. Modak and another. Eastern Book Company versus D.B. Modak. Now, in this case also, the matter was decided in relation to compilation. And what court says, court adds CCH Canadian with Macmillan versus Cooper. In CCH Canadian, what we said, the work must be the result of application of your skill and judgment and labor, plus it must have creativity, not in the sense of novelty, not in the sense of non-obviousness, but there must be some creativity. That is what we said. Now, this paragraph was taken from CCH Canadian and the Indian court adds that, and the resulting work must have some distinguishable features and flavors to raw material. This part, the derivative work, the resulting work must have some distinguishable features and flavor to raw material. This part is derived from Macmillan versus Cooper. So, what we have done, we have added the observation of CCH Canadian and Macmillan versus Cooper to lay down the test of originality in India. So, what therefore is the test of originality in India? The resulting work must be the result of application of labor, skill and judgment. It must be creative, not in the sense of novelty, not in the sense of non-obviousness, and the resulting work, the derivative work, must have some distinguishable features and flavors to raw material. But important thing here is to note that even this case relates to compilations, databases. So, one thing is clear that for databases, for compilations, the test to be applied, whether in USA, whether in Canada, whether in India, will be minimum modicum of creativity. However, I believe that there is some problem here, because when we talk about creativity, it is a subjective concept. Something may appear to be creative to me, it may not appear to be creative to you. So, who will finally decide whether the work in question is creative, sufficiently creative or not? So, that brings uncertainty. Second, if you recall, I said in the beginning in my first slide that in copyright law, barring few subject matter, we are not going to determine the quality of the work. When we talk about creativity, we are actually talking about quality. A work which is not at all qualitative, can it be called as creative? So, the problem with this test is it brings in the element of quality determination within copyright law, 1. 2, it brings in subjectivity as to who will finally decide whether the work in question is sufficiently creative or not. So, therefore, I will prefer to follow sweat of brow in most of the cases, because courts have mentioned application of modicum of creativity test mainly with respect to compilations. So, therefore, let us conclude that for compilations definitely we are going to follow creativity test, but I think we have liberty to follow sweat of brow test, which is more objective to apply, which seems to be more objective to apply with respect to rest of the works. So that is about originality. If you go back to section 13, if you recall what I said in section 13, I said the list of subject matters is original literary, dramatic, musical, artistic works, cinematograph, film, sound recording. Originality is a requirement with respect to first 4 works which I mentioned, and we have understood the meaning of the term originality. It cannot be determined by adopting comparative approach. It has to be an inherent test. In sweat of brow, we said anything which is the result of application of your labor, very small, good enough. In creativity, we said in addition to labor, the resulting work must also be creative. Now, let us try to understand the other words which are used in section 13.1. The first in series is literary work. What do we mean by literary work? It is defined in section 2.0 of your act. But if you read section 2.0, it is only an inclusive definition. It will only say that literary work will include computer programs, computer databases, tables and compilations. 2.0 does not define it. It is an inclusive definition. Now, how to define it? I have tried to give you a definition here. If you see, any work other than dramatic or musical work, because dramatic works are also written, musical works can also be written. So, it is not that anything which is written, printed is literary. So, any work other than dramatic work or musical work which is written, printed, spoken, sung, uttered is literary. So, any work other than dramatic or musical work which can be written, printed, spoken, sung, uttered is a literary work, and accordingly then it includes tables, compilations, computer program, computer databases. There is a useful case here, Hollinrake versus Trueswell. It is an English decision in which the court said that in order to be called as a literary work, the work must fulfill one of these 2 requirements. First, it must give some information or instruction, and second, it must give some pleasure in the form of literary enjoyment. So, it must either give some information and some instruction to whom? To somebody at least in this world, and second, it gives pleasure in the form of literary enjoyment. Now, I will not include this thing in my definition, because when we talk about pleasure, when we talk about literary enjoyment, we are talking about quality. I don't want to include quality in my definition because that will bring subjectivity. So, now how I will define it? Any work other than dramatic or musical work which can be written, printed, spoken, sung, uttered, and which gives some information or instruction to somebody in this world is a literary work, and it includes tables, compilations, computer program, computer databases. So, that is how we can define. Otherwise, 2.0 is only giving me what all is included. So, any work other than dramatic or musical work which can be written, printed, spoken, sung, which gives some information to somebody at least in this world, and which includes computer program, computer databases, tables and compilations is a literary work. There is a question which I have raised here, whether names, titles, catchphrases are protected. At one point of time, we used to consider that names, titles, catchphrases, slogans are not sufficiently original. For example, in a Delhi High Court decision of 2001 called as PepsiCo Incorporated versus Hindustan Coca-Cola, the Delhi High Court said that generally no copyright is given on slogans. So, this is the general understanding. I will not go in detail of this aspect because that will take a lot of time, but generally it is believed that names, titles, slogans, catchphrases, these are not sufficiently original, therefore, these are not generally original, therefore, no protection is granted. However, I believe if you come out with a very creative slogan or a very creative catchphrase, you can still claim copyright because the general presumption may be defeated. As I said, it includes tables, compilations. It is not difficult to understand what is tables and compilations. It includes a computer program. A computer program means a set of instructions which is when given to hardware, you get a desired result performed. Computer program, yes, it is written in human readable language. There are certain high languages. Those who know about coding, they will understand the languages. Now, all the computer program which is written in human readable language, which humans can read, is called as source code. But machine cannot read this language. So, therefore, machine will first of all convert this source code into a language called as object code, which is a machine readable computer program. The definition of computer program in your act includes source code as well as object code. So, therefore, both of these are protected under literary work category. So, therefore, computer program includes source code as well as object code. It also includes computer databases. I am sure you must be aware a database is a compilation of discrete data. For example, I collect names of all the airports in India and arrange those names in some particular order. That becomes a database. A computer database is a database from which an individual data may be obtained electronically. That is also included in the definition of literary work. So, 2O needs to be supplemented by a case Holland-Drake versus Trueswell to understand the true scope of the meaning of literary work. Keep in mind that the literary work has to be original in order to get protection. Now, let us come to the second word now, the dramatic work. Dramatic work has been defined in section 2H. It has got three parts. Section 2H has got three parts. You have inclusion. Surprisingly, you have a part on criteria for protection, and then you have exclusions. What all is included, what all is excluded, and when a dramatic work will get protection. These are the three parts of the definition which you have in section 2H. Inclusion. It says any piece of recitation, any choreographic work, or any entertainment in dumb shows. These are dramatic work. So, any piece of recitation is a dramatic work. Choreography, if I show you some steps of some dance steps, it is choreography. There must be professional methods of writing choreography. Choreography is a dramatic work, and entertainment in dumb shows is a dramatic work. These are inclusions. Does not mean only these are dramatic works. These are inclusions. The second part is about criteria. This is important because you see I have written it in bold. The provision says that any piece of recitation, choreographic work, or entertainment in dumb shows, the scenic arrangement or acting form of which is fixed in writing or otherwise. So, what is important to note here is the definition gives me the requirement of fixation. Your work is not a dramatic work unless it is fixed. Let us go back to the first slide. I said in order to get protection, the work must be fixed. And if I go back to section 2O, 2O which defines literary work nowhere says that in order to be called as literary work, the work must be fixed. Fixation is an overall condition for getting protection. You write in the definition or not, it is still a requirement to get protection. So, a literary work is a literary work irrespective of requirement of fixation according to section 2O. But surprisingly, a dramatic work is a dramatic work only once it is fixed in some form, whether writing or otherwise. This may not be there because writing this creates a doubt as to whether fixation is a requirement only with respect to dramatic work. Because we will see in the definition of musical work, in the definition of artistic work, you do not have this thing mentioned that it must be first of all fixed. So, mentioning it only in 2H may create doubt as to whether it is a requirement only in relation to dramatic work or whether it is a requirement for all. Let me tell you, you write it or not, it is still a requirement for getting protection under Copyright Act. The third part is exclusion. Cinema is not dramatic work. Why do we exclude cinema? Because probably at one point of time we used to think that cinema is a dramatic work. At one point of time probably we used to give protection to cinema as dramatic work. So these are the three things. You have inclusion, that does not give me much information. You have criteria, that may create some confusion. You have an exclusion, that makes sense because cinema is a separate subject matter. We will discuss the meaning of cinema in section 2F. But as with literary work in 2O, here also you don't have a definition. We can get a definition from the case called as Green versus Broadcasting Corporation of New Zealand. Green versus Broadcasting Corporation of New Zealand, in which court defines dramatic work as any work of action. So, static things are not dramatic work. Set of a show is not part of the dramatic work. So, it has to be a work of action, and second, which is capable of being performed. So, these are the two requirements for a work to be called as a dramatic work. Any work of action which is capable of being performed is a dramatic work. What happened in Green versus Broadcasting Corporation of New Zealand? There was a format of a program. The format was that there are sponsors who are introducing participants. Participants are making performance. There are three judges who are evaluating the performance, and there will be audience sitting in the hall who will clap. There will be a clapometer installed. That clapometer will measure the intensity of clapping and will convert it into marks. The marks of judges and the marks which we get from this clapometer will be added together to declare who is the winner. That was the format of the show. Defendant copied the format. The title was Opportunity Knocks. Defendant copied the title also. I just said that titles usually are considered not sufficiently original, therefore there is no protection on titles. The format was copied. Plaintiff files a case against defendant for violation of copyright in dramatic work, saying that my format of the show is a dramatic work. Court comes to the conclusion that this definitely appears to be a work of action, but the format alone is not capable of being performed. Unless you supplement the format with the content, you cannot perform the format alone. And therefore, court declared that format is not dramatic work. Now, important point here is, definition of dramatic work is any work of action which is capable of being performed. Coming to the third point, that is exclusion, which I mentioned, it does not include a cinematograph film. A cinematograph film is not considered as a dramatic work. Initially, cinema was protected as series of photographs. Then probably we started thinking that cinema is a dramatic work because something moving on the screen. But then there will be problems. I don't want to go in detail here because there are certain cinematograph film which employ techniques to convert actions which become humanly impossible to perform. How will you claim protection on those cinema, because court will ask you to perform those. Court may say that these such cinema are not capable of being performed. So therefore, this is rightly included as a separate subject matter. We will talk about it later on in section 2F. So section 2H therefore defines an artistic work, and for me the definition of 2H needs to be supplemented by the definition given in the case of Green versus Broadcasting Corporation of New Zealand, and the definition now is dramatic work is any work of action which is capable of being performed. That brings me to the third word used there, which is musical work. Section 2P defines musical work. Musical work means a work consisting of music. Musical work means any music. Musical work means any music. There can be two kinds of music. One is unwritten music, the other is written music. One may tend to conclude that because the definition of musical work includes any music, So that means even unwritten music is musical work, that is true. That means the entire folk music which we have is part of the definition of musical work, that is unwritten music. And can we therefore conclude that therefore the folk music is protected under copyright? I think no. Because as I have already mentioned that fixation is a precondition to get protection. Even if you don't write it in the definition, it still remains a precondition to get protection. Because folk music by and large is unfixed, unwritten, unrecorded, so therefore it may not get protection. Further, even if we argue that it is recorded somewhere, still the duration of protection of folk music must have elapsed. Another problem in relation to folk music will be to identify the owner of copyright in relation to those music. We do not consider copyright to be a right owned by a collective of people. It is not a collective right. So these are some of the issues associated with folk music. However, coming back to section 2p, the definition includes any music, whether it is written by graphical notations or whether it is unwritten. But it does not include any word or action sung, spoken, performed with the music. So music means musical notes, the tune, the composition. And anything spoken or sung along with that music is not musical work, it is literary work, it is lyrics, it is covered under section 2O. So what I can conclude, there is no copyright in a song as such. The song as such is not one subject matter of copyright. There are many rights in one song. Lyricist will claim copyright on lyrics. The composer will claim copyright on musical work. Singers will get protection under performers' rights. Section 38 will discuss later on. All the people who are playing various instruments will claim protection under section 38, performers. So there are many right holders, but song as such is not one subject matter. So therefore, musical work means any music, whether it is written or unwritten, but the protection will be granted only once the work in question is fixed. And that is why I said that although it includes folk music, but it may not be protected because it may not pass the criteria of fixation. Coming to another word called as remixing, you must be familiar with this word. What is remixing? If a music arranger so decorates, develops, transfers to a different medium or otherwise changes the simple music of a popular song as to make his arrangement fall within the description of an original musical work, it will get protection. It has to be significantly changed in order to get protection. What has to be changed? The music. The written music has to be changed. Although maybe later on we will discuss that courts don't apply the test of comparing written music. Courts will listen to both the tunes, and if they conclude that the tunes sound alike, they may decide that it is violative of original tune. However, the fact is that if the new composer rearranges it in such a manner that it altogether becomes an original work, then even if it is sound alike, it deserves protection. That is about remixing. So 2p defines musical work. The important observation here is that musical work, the definition includes written as well as unwritten music. But as I have been saying, to get protection, you need to fix the music. So therefore, written music will get protection under Indian law. And the last observation which I have written here is there is no copyright on the song as such. The song has got various components and there will be different right owners in those different components. So 2O defines literary work, 2H defines dramatic work, 2P defines musical work. These three works must be original in order to get protection. And the final word in this list is artistic work, section 2C. And this is an exhaustive list. This is not inclusive. Unlike section 2O or 2H. In 2O we said that literary work includes A, B, C, D. In 2H we saw that dramatic work includes A, B, C, D. In 2C what it says, artistic work means these. So it's an exhaustive list. Only these are artistic work. What are the words mentioned? You see there are 3 clauses. You can see here 1, 2, 3. The first clause has got many words. A painting is an artistic work. A sculpture is an artistic work. A drawing. Drawing does not mean very qualitative drawing. Diagrams, maps, charts, plans, very basic drawings are artistic work. An engraving is an artistic work. Photograph is considered as artistic. So these are artistic. Now this is an exhaustive list. You cannot add anything to it. For example, a sculpture is an artistic work means what? Only the sculpture, not the mold which you use to create the sculpture. Although one may argue that you need to employ more effort in creating molds. But still, because my provision says only sculpture is protected, molds, however creative it may be, will not be the subject matter here. So it's an exhaustive list. Apart from the fact that it's an exhaustive list, you see there is an observation written here, there is a point written here, whether or not any such work possesses artistic quality. So these are artistic. A painting is artistic even if it may not be artistic in quality. A sculpture is an artistic work even if it is not artistic in nature. So painting, drawing, sculpture, engraving, photograph, these are artistic works irrespective of artistic quality. But you don't have this statement written in the second clause, in the third clause, meaning thereby these are the 2 subject matter, work of architecture and any other work of artistic craftsmanship, in which we have to examine the artistic quality. And if you remember, if you recall, I said in copyright, by and large, barring few subject matter, we will not get into determination of quality. These are the 2 subject matters in relation to which we need to determine quality, and we will see the problems in determining quality. So now let's understand these words one by one. The first is painting. I have mentioned a case, you see, merchandising versus harp band. This is a case in relation to facial makeup, whether facial makeup is painting or not. Now, I am not referring to routine facial makeups, I am referring to the loud makeups which artists in certain dance forms do. Whether that is painting or not, court said painting means paint on a surface. So, if you have applied paint on a surface, it is painting. In relation to facial makeups, court said it is not painting because it is not intended to be permanent. Something which is not intended to be permanent will not be the subject matter of copyright. I don't think this is one of the criteria in copyright law. I said the only criteria to get protection is your work must fall in one of the categories identified in section 13(1). Your work must be original if it is literary, artistic, dramatic and musical, and your work must be fixed. I did not say that one of the requirements is that the work is intended to be permanent. So that does not, to me, is a sound basis to say that facial makeups are not protected. Because if that is the basis, what will be the law on tattoos which are intended to be permanent? There are certain very classic ice sculptures which may not be intended to be permanent, still they deserve protection. So therefore, something which is intended to be permanent will only get protection does not form a good basis. What we could have argued is that face cannot be a surface. When we use the word surface, probably we intend to mean something inanimated. So on that basis, we can say that facial makeup is not painting. But this is open, you can develop your arguments on this question. What is important for me is painting means paint on a surface. The second word used is drawing. Drawing, as I mentioned, it includes sketches, architects' plans, dress design, even very elementary drawings, engineering diagrams, circuit diagrams, all these are drawings, all these are artistic works. We don't require artistic quality in these works. The third word is engraving. If you look into dictionary, engraving means cutting, but we are not concerned with any cutting. We are concerned with the marking, cutting or working the surface, typically the flat surface. You work on a flat surface to get an image coming out of it. That kind of cutting, that kind of marking is something with which we are concerned when we are using the word engraving. The next word is photograph. Photograph, as the name suggests, it is an ill-suited subject matter for copyright because photograph is essentially a copy. It is essentially a copy because if you have the subject, you can click it. If the subject is not there, you cannot click it. But gradually we realize that photography is a skilled art and then it must be granted protection. A photograph may be defined as recording of light or other images from which still images may be obtained. The next is sculpture. As I already mentioned, sculpture will get protection. The molds to make sculpture will not get protection. Whether the object made is sculpture or not is to be determined on the basis of the factor as to whether the maker was consciously concerned to create a piece of art or was he creating something in order to achieve some functionality to be performed. So that distinguishes whether it is sculpture or not. As I have already mentioned, artistic quality is not a requirement in section 2C1. In 2C2, there is another work mentioned called as work of architecture. You don't have this word artistic used here with work of architecture. But if we read the definition of work of architecture given in section 2B, we will come to the conclusion that artistic quality is required. Work of architecture, fixed structure, building, path of building, these are architecture. There are certain factors which are used to determine whether it is work of architecture, for example, size, whether it is portable, degree of permanence, all these factors will tell us whether the work in question is work of architecture or not. 2C3 is work of artistic craftsmanship, beautiful handicraft jewelry, beautiful pots, beautiful glass windows, beautiful iron gates, etc. Why I am using the word beautiful? Because this has to be artistic. It is not work of craftsmanship alone. It is work of artistic craftsmanship. In the case of Hensher versus Restavile Upholstery, 1976, House of Lords tried to explain how to determine artistic quality of the work of craftsmanship. Lord Reed says, when the substantial section of public genuinely admire and value a thing for its appearance, it is artistic. Will you go and talk to substantial section of public? The second test, Lord Morris says, don't talk to substantial section of public, talk to the artist and talk to the person who is acquiring the work. If they consider it to be artistic, accept that it is artistic. I can tell you the two people in the world who will always say that the work is artistic is the one who has made it and one who has purchased it. What kind of test is this? Third is Lord Kilbrandon, who says that circumstances are important. See whether the maker was consciously concerned to create a piece of art. If the maker wanted to create a piece of art, whatever he created is artistic. This cannot be accepted because whatever he created may be hopelessly non-artistic. So, are we judging the artistic quality of the work or are we judging the fact that whether he wanted to create an artistic work? Then there is another judge, Viscount Dilhorn, he says, decide according to, leave it to the intuition of judges. Judge may not be qualified to determine whether it is artistic or not. Finally, Lord Simon says, we will go by expert evidence. Who is the expert finally? Who will finally decide the artistic quality? Who is an expert will always have the element of subjectivity. So that is only to tell you that determination of quality is a difficult task. It involves a lot of subjectivity. But fortunately in copyright law, except for artistic craftsmanship and work of architecture, We are not required to get into determination of quality. Section 2F defines cinematograph film. Cinema means any recording from which visual images may be obtained. Any soundtrack accompanying cinema is considered part of cinema. And section 2XX defines sound recording. It can be easily defined. Sound recording means recording of sound. Sound does not belong to the producer, HMV or T series. Sound belongs to the content creators, the lyricist, the composer, the performers. It is only the recording which belongs to producer of sound recording. It is only the recording which belongs to producer of cinema. So in these two, these may be called as entrepreneurial works, because here the enterprises are more important. Producers are getting right, and what belongs to producers is only the fact of recording. Since there is no creativity involved in recording, so therefore law does not require these works to be original as per section 13. So therefore, what we discussed in this session is, we discussed the list of subject matter. I said in American law they have an open-ended provision. In Indian law we have a close-ended provision. There are merits and demerits of both the provisions. We defined all the terms which we have used in section 13, including the word originality. I am sure now you are familiar with the subject matter of the copyright. In the next lecture, we'll talk about meaning of copyright. We'll talk about section 14. That's all on the subject matter of copyright. Thank you very much for joining. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I'm not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I'm also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.